Welcome back to the series. Last time I talked about stare decisis. Stare decisis is a doctrine that judges must decide according to the decision made, especially by higher courts or higher judges above them. We have stood in common law countries with that principle. Now, today I want to talk about the different methods of discovering of the truth in the legal systems. In common law, the most important system in which we decide the truth. Remember, law is established principles which govern behavior in a particular domain or particular jurisdiction. But the most important aspect of the law is to coordinate justice so that the application of the law is not arbitrary and it is not also whimsical, so that one officer can just rise up and doctor the law as they will. No, the law must be central, unifying as well as stable, applied uniformly across the board. If there is any way in which the law is favoring one sector at the expense of the other, we might say that's not a good law. So in the quest to find the truth, in the common law system, they have developed a principle known as, this is adversarial. In other words, combatants, legal argumentatives, and legal contestants must meet as though they were having a battle of the minds. This is not a battle with machetes and machine guns and rifles. This is the battle with the brains and the law, using all these combination of principles and legal traditions to bring out the winner. So in the common law system, to find the truth, they invented a system known as adversarial process. This adversarial process involves what we call the presentation of evidence. So there are two contestants. If it is in a civil case or in a case that deals with money or monetary gain or losses, there will be a plaintiff, the person who starts the case, and there will be the defendant, the person who wants to defend. And there's going to be the trier of fact or the trier of law. Now, in certain places, the trier of fact, the one who decides on the fact, is usually a jury of peers. In other jurisdictions, the judge can play the two roles, can both be the trier of fact, he tries the stories, and can also be the trier of law. He understands and applies the law to the judgment. So, the judge's role in the common law system is a gatekeeper. He is the one who is like a referee, a neutral person who listens from the presentations of lawyers from both sides and decides to make the decision at the end. But the lawyers, what we call the legal representatives or counsel, whatever name you might give them in various parts of the world, attorneys, whatever the case, their job is to try to convince that their side is legitimate and more gravitas and more weighing than the other side. So the judge can now weigh the evidence and the presentation of the same. The presentation of evidence requires three procedures. The first one is that the one presenting must do examination in chief of their witnesses. The other name for examination in chief is known as direct examination. And then they must allow the other side to cross-examine them or their witness. And if there is chance for mending some areas, the attorney or the lawyer or counsel or the representative started with the questioning can re-examine. And then the judge, the gatekeeper, is going to give these two sides an opportunity to make what's called closing arguments. And then the judge, who is the trier of fact or the trier of law, is going to decide based on the presentation of both sides. Next time, we'll make headway on this issue and look how they decide cases in civil, traditional kind of countries. Thank you.